Welcome back to the High Court Report. I come to you today with takeaways and predictions from the oral arguments in 3 cases we heard last week: National Republican Senatorial Committee versus FEC, Hamm versus Smith, and FS Credit versus Saba. Subscribe, rate, and share for ongoing Supreme Court coverage. Find us on Apple, Spotify, YouTube, and LinkedIn. Subscribe on YouTube for shorts and additional analysis. Last Tuesday, I provided my takeaways about Trump versus Slaughter, the FTC firing case, whether the president can fire the commissioner of an independent agency without cause when U.S. code permits their removal only for cause. Check out my 6-pack. I point out the oral argument fault lines, dropped a few other nuggets, and predicted the outcome. I like trying to predict the outcome, so I'm going to give more post-argument predictions starting with today's episode. You've probably noticed a ton of changes lately. We have an absolute ton of irons in the fire. Please bear with me, I promise. We're constantly trying to elevate. Also, I'm still trying to figure out my posting schedule the next couple of weeks. There's a few areas I want to cover with you all. End of the year, wrap up, where we stand for 2025 cases, 2026 preview. But that'll probably ramp up after Christmas. In the meantime, listen to our archives. We have a ton of content, oral arguments dating back to 2021, and breakdowns of the 2024 term opinions. Check them out as you finish up your holiday shopping. Finally, check out our YouTube page. I'm definitely going to post shorts over the next 2 weeks. I include 30-second to 3-minute clips from key moments with descriptions that explain their significance. Follow us on YouTube to see. Okay, let's dive into this past week's cases. Let's start with National Republican Senatorial Committee versus FEC, a case that could fundamentally alter American campaign finance. This argument had everything: jurisdictional drama over J.D. Vance's political future, heated exchanges about corruption theories, and justices questioning whether our entire system of legal distinctions around political spending makes any sense. Let's start with the elephant in the room. Vice President J.D. Vance appeared as a plaintiff in this case, but his political plans became a major issue. The court-appointed lawyer, Roman Martinez, argued Vance's claim should be dismissed as moot because he hasn't committed to running for office in 2028. Martinez put it bluntly: Vice President Vance has repeatedly denied having any concrete plan to run for office in 2028. He added, "If any other plaintiff in this court told you that his injury is speculative, that it's uncertain, that it's premature, that it might happen, and it might not happen, they wouldn't have a prayer under Article 3. The same rules apply to the vice president. There's no politician exception to Article 3, but the Republican lawyer, Noel Francisco, fought back hard on this point. He argued that virtually every vice president goes on to run for the presidency, particularly young ones like Vice President Vance. Francisco pointed out that Vance has an active statement of candidacy, an active Senate campaign committee that's already raised $50,000 this year alone, and at least 15 of the last 18 vice presidents have gone on to run for the presidency. What struck me was Francisco's line about political reality. This court doesn't have to blind itself to the reality that's obvious to everybody else, essentially arguing that, of course, J.D. Vance is planning to run. Everyone knows it even if he won't say it explicitly. Moving to the constitutional merits, one of the most telling exchanges came when Chief Justice Roberts called out what he saw as a fundamental fiction in campaign finance law. He asked Francisco, "It's important for you to draw a distinction, isn't it, between coordinated expenditures and actual contributions? And if so, how do you tell that? It seems to me that that's kind of a fiction that, they're just coordinated expenditures. They're not making direct contributions. I don't know in substance what the difference is." That question cuts to the heart of everything. Roberts was essentially saying, if a party coordinates with a candidate on spending, how is that meaningfully different from just handing them cash? The Chief Justice used this example. You see, the candidate is giving speeches on opposition to a particular farm subsidies or whatever, and then you can start engaging in speech on that same platform, that same priority. And I don't see that there's much difference between giving him the money to let him do it and doing it yourself. One theme that kept coming up was the concern about super PAC dominance over political parties. Justice Kavanaugh seemed particularly interested in this angle. During questioning, he explored whether parties had become weaker and weaker, while super PACs grew stronger, and whether this was bad for democratic governance. The Republican lawyer leaned hard into this democracy argument. Political parties serve a moderating influence by forcing essentially compromises within a party in order to put forward a platform and to put forward candidates, whereas PACs and super PACs can often be focused on narrower issues, the idea being that stronger parties mean more moderate, coalition-building politics. But then Justice Alito asked what I thought was one of the most revealing questions of the day. He wanted to know who is helped and who is hurt by the provision that is before us. This was clearly aimed at exposing whether the party's positions were driven by constitutional principle or partisan self-interest. The Republican response was pretty telling. Francisco acknowledged that historically both of the parties have been aligned on this issue, but then speculated, I think one answer might lie in the fact of where the different parties' relative fundraising strengths have been over the years. I think that there's some sense that the Republican Party apparatus is raising more money relative to the candidates, whereas the Democratic apparatus, the candidates are raising more money relative to the party apparatus. So basically, admitting that Republicans might support this because it helps their fundraising model, while Democrats oppose it because it hurts theirs. Not exactly a ringing endorsement of principled constitutional interpretation. When the DNC's lawyer, Mark Elias, got up, he made a fascinating argument that eliminating coordinated spending limits would actually weaken parties rather than strengthen them. He argued that the practical effect of petitioner's case would be to convert the political parties into mere paymasters to settle invoices from campaign vendors. Elias claimed that the vast majority of them hardly involve speech at all, meaning most coordinated expenditures are just paying campaign bills, not engaging in independent party speech. His argument was that unlimited coordinated spending would turn parties into glorified check writing services rather than independent political institutions. What struck me throughout was how the justices seemed to split along predictable lines. Sotomayor and Kagan were clearly defending the current system, while Kavanaugh seemed sympathetic to strengthening parties. Alito appeared skeptical of the Democrats' motives. Roberts called out the legal fictions, but didn't clearly signal which way he was leaning. Barrett was notably quiet throughout, asking very few questions. That could signal she's already decided or that she's keeping her cards close as a potential swing vote. This one was a little tough to predict. Justice Barrett asked only one question. Justice Gorsuch asked none. I tally 3 for NRSC, Thomas, Alito, Kavanaugh, 3 for FEC, Sotomayor, Kagan, Jackson, and 3 unknown, Roberts, Barrett, Gorsuch. I think the NRS will get the 3 unknown votes and will win 6-3. Next, let's discuss Hamm versus Smith. This oral argument revealed some fascinating tensions. The justices spent over 2 hours wrestling with a deceptively simple question. When someone takes 5 IQ tests and scores 75, 74, 72, 78, and 74, do courts look at that single score of 72 in isolation or evaluate all scores together? What makes this so compelling involves the constitutional stakes. Joseph Smith murdered Dirk Van Dam in 1997, a brutal killing involving 35 blunt force injuries. Smith faces execution unless he proves intellectual disability under the 8th Amendment's ban on executing intellectually disabled individuals. But here's the twist that emerged during oral arguments. No justice clearly embraced Alabama's pure IQ-only approach. Chief Justice Roberts delivered particularly pointed questions that seemed to expose what he called Alabama's results-oriented methodology. Yesterday's arguments revealed 3 distinct methodological approaches, and the justices' reactions tell us everything about where this case might land. First, Alabama's bright line IQ approach. Alabama argues that when multiple IQ scores exceed 70, courts should treat those scores as dispositive evidence against intellectual disability. They propose 5 statistical methods: median scores, composite scores, overlap analysis, average scores, and highest score emphasis. But here's what emerged during questioning. Chief Justice Roberts delivered a devastating hypothetical that exposed potential inconsistency in Alabama's approach. He asked whether Alabama would apply the same methodology if someone scored 69, 68, 69, 69, and 75, basically flipping Smith's pattern. Roberts then delivered this pointed observation. You can see why that might appear results-oriented. When you scores above 70, you want to average them and discount the one below, but when they're all below, you don't do that. That question reveals Roberts testing Alabama's logical consistency. Would they apply identical statistical analysis regardless of which side benefits? Alabama's counsel struggled to provide a convincing answer. Smith's attorney, Seth Waxman, advocated for comprehensive evaluation including IQ scores, measurement error analysis, adaptive functioning evidence, and expert clinical judgment. He emphasized that Alabama law itself requires courts to evaluate all probative evidence rather than mechanical score counting. Justice Jackson emerged as Smith's strongest advocate. She repeatedly challenged Alabama's IQ-only approach, citing the American Association on Intellectual and Developmental Disabilities amicus brief, stating that too many variables exist to rationally support using only one procedure. Jackson emphasized that clinical experts must look at lots of different things to determine whether someone actually exhibits intellectual disability. She seemed skeptical of categorical rules that impinge on expert assessment. The most intriguing development involves the Solicitor General's compromise position, which seemed to attract judicial interest from multiple justices. The government argues courts should start with IQ scores, proceed to consider additional evidence, but then circle back to weigh that evidence against the collective IQ data. Justice Kavanaugh explored this approach extensively, asking whether courts must consider all other evidence but not forget about the scores during final evaluation. This methodology preserves judicial consideration of comprehensive evidence while preventing courts from simply ignoring numerical IQ data. Based on yesterday's questioning, Justice Jackson clearly favors Smith's comprehensive approach. She asked pointed questions about Alabama's methodology and emphasized clinical complexity. Justice Sotomayor also challenged Alabama's procedural arguments and questioned whether Alabama courts actually follow the rigid approach Alabama advocates. Chief Justice Roberts appears skeptical of both extreme positions. His questions suggest he seeks consistent, principled methodology rather than results-oriented analysis. Justice Kavanaugh seemed most interested in the Solicitor General's middle ground approach. Justice Alito asked questions about categorical rules and national consensus, suggesting potential sympathy for Alabama's position. But even Alito didn't explicitly endorse pure IQ-only analysis. Here's my prediction based on yesterday's arguments. The court will reject Alabama's most restrictive approach while also declining Smith's most expansive holistic standard. They'll likely adopt something resembling the Solicitor General's methodology. This case reflects deeper tensions about federalism and constitutional interpretation. Alabama argues Adkins preserves essential state discretion in defining intellectual disability standards. Smith contends the Eighth Amendment requires constitutional minimums that prevent arbitrary state variations. Finally, let's discuss F.S. Credit versus Saba. His case tackles something courts call implied private rights of action, basically whether Congress intended to let private parties sue to enforce a particular law, even when Congress never explicitly created that right. And what makes this particularly fascinating, activist investors like Saba Capital discovered that 4 closed-end investment funds traded at massive discounts to their underlying asset values. When Saba tried to accumulate shares to force management changes, the funds adopted poison pill defenses that stripped voting rights from any shareholder owning more than 10%. So Saba sued, claiming these restrictions violated federal securities law. But here's the twist. They couldn't point to any explicit congressional authorization to bring that lawsuit. The Supreme Court now decides whether Section 47B of the Investment Company Act creates an implied federal cause of action. And here's where things got really interesting during oral arguments. Justice Kavanaugh emerged as a potential swing vote, expressing serious concerns about the very bizarre and anomalous results that would follow if investors face relegation to state courts rather than federal courts. Kavanaugh repeatedly questioned FS Credit's lawyer about how this would actually work in practice. If there's no federal private right of action, where do these cases go? State courts lack clear authority to handle federal securities law claims. Paul Clement, representing Saba, hammered this practical point. He argued that FS Credit's defensive-only interpretation would render the statute nugatory because investment funds essentially never sue their own shareholders for breach of contract. Right. Under FS Credit's theory, shareholders would have to wait indefinitely for lawsuits that will never come. Fund managers aren't going to sue the very shareholders they're trying to control. Moving on, the arguments featured extensive debate over legislative history. Justice Sotomayor aggressively pressed on 1980 congressional reports showing lawmakers intended to preserve private rights of action. She cited specific House and Senate report language stating that private rights of action should be implied to aid in enforcement, and that Congress expects the courts to imply private rights of action under this legislation where the plaintiff falls within the class of persons protected. When FS Credit's counsel argued that Sandoval requires focusing solely on text and structure, Justice Sotomayor pushed back, "I don't know how much more decisive on congressional intent than those statements are." But here's where Justice Gorsuch provided a counterweight. He focused on separation of powers concerns, asking whether courts have any more power to imply modest versus substantial causes of action. Gorsuch seems skeptical of implying any cause of action, emphasizing that the people are supposed to write the laws that govern them, not judges. He repeatedly pressed both sides about the constitutional authority for courts to create private enforcement mechanisms. Justice Barrett asked nuanced questions about clear statement requirements and seemed concerned about the breadth of any implied right. She questioned whether Sandoval actually requires a clear statement or just ordinary statutory interpretation. The liberal justices plus Justice Kavanaugh appear troubled by completely eliminating federal private enforcement, while conservative justices remain concerned about separation of powers issues. Justice Kavanaugh's position appears pivotal. Here's my prediction. Ruling for Saba, meaning the court permits shareholders to sue to rescind contracts. Kagan, Sotomayor, and Jackson seem ready to rule for Saba. Kavanaugh makes 4, meaning Saba needs only one more justice to win. I tally 1 for FS Credit, Gorsuch. That leaves 4, Chief Justice Roberts, Justice Thomas, Alito, and Barrett. Justice Barrett did not ask many questions, but when she did, she seemed skeptical that the higher statutory interpretation standard, clear statement rule, applied here. I think she sidesteps the clear statement rule and votes in Saba's favor. That's 5. Saba wins. We'll see whether it shakes out 5-4 or if Saba can pick up 1 or 2 more votes. We'll definitely cover the decisions when they drop by June 2026. We'll of course provide ongoing coverage of all decisions. That's it for today's episode. Thanks for listening to the High Court Report. Please follow, rate, and share the podcast. And connect with us on YouTube, LinkedIn, at the High Court Report for ongoing coverage of this transformational case term. Talk to you soon.